यहाँ से 22 जाते जाते बैठ तो नहीं जाएंगे? हाँ, कि यहीं से देख लो, कि यहीं से
Consequently, the following order is passed. The criminal revision petition CRR 3494 of 2022 is dismissed. The impugned order dated 18th June 2022, passed by the learned FTC First CT Session Court, Calcutta, in Criminal Appeal number 108 of 2020 is hereby affirmed. The petitioner is directed to appear before the learned Metropolitan Magistrate, 12th Court, Calcutta, on the next date of hearing and participate proactively in the fresh inquiry in Miss Case number 7 of 2019. He shall file his affidavit of assets and liabilities as required under the law. The learned trial judge is requested to endeavor to conclude the fresh inquiry and pass a reasoned order on all prayers expeditiously and preferably within the time frame stipulated in the remand order. Interim orders, if any, stand vacated. There shall be no order as to the cost.
Lordship, I am for the opposite party. Why?
Yes.
Yes, sir. Lords.
Then you enjoy.
Grateful, Lords.
Thank you. Okay.
Item number 2, I'm appearing for the petition. There is an extension application. The application has been filed in time limit. If your lordship kindly extend the interim order.
But within time. Learned advocate for the petitioner is present. Yes. Item number 2.
Item 2, I am for the appearing for the
opposite party.
No, who is for the OP or state?
Sorry.
Yes, Mr. Rai, are you for state in item number 2?
Item number 3.
Okay, just wait, just take your breath.
No,
Yeah. Learned advocate for the petitioner is present. You are for the
I
OP.
am for the opposite party. Opposite party.
OP number 2, private OP.
Yes, my lord.
OP number, yeah, OP estate and private opposite party number 2 is also represented by their respective advocates. CRAN 5 of 2025 is taken up for hearing. आगे लिखे थे learned advocate for the petitioner file affidavit of service on the OPs is taken on record. তারপরে CRAN 5 of 2025 is an application for extension of interim order. When the interim order was first?
Well, the
4th July.
the interim order initially was granted on 26th of June 2023.
Passed on 26th June 2023.
And thereafter it has been time.
And the same has been extended time to time. He submits that this application has been filed within time. Do you have any objection?
No, my lord.
Should I record your
Yes, my lord. Yes, my lord. Let the
learned advocate for the OP number 2 and OP number learned advocate for the OPs did not raise any objection to the extension of interim order granted earlier. Let the interim order extended till the first week after the vacation. What is the stage of hearing?
Well, we have filed our, they were supposed to file their opposition.
Then
my lord fix the date. We will file.
how long time you need?
Next date. Next date. We will file
Next week.
next week.
So I am fixing it on 19th.
Well,
Much obliged.
kindly do not fix it prior to the vacation.
No, sir. Then I will not extend your interim order. This is not fair. This matter is pending since when?
2023. This is too.
Then already 2 years has been passed.
Give me for a moment, Millet. If they come up with the application for the if the affidavit in opposition on next week, we have to give a reply to that.
Yes,
But that will take us the last day on 20.
I will hear you on that day. No, not last day. Learned advocate for the OP number 2 prays for time to file affidavit of opposition to revisional application.
Yes, my lord.
Revisional application.
To the revisional application. He is directed to file the affidavit by 19th September. Let this matter adjourn till 19th for filing of affidavit in reply,
Opposition, my
affidavit in opposition by learned advocate for the OP number 2.
Your lordship is extending 1 week after vacation and keeps it on 19th.
Yes.
Dispose of this application.
Yes, yeah. Current 5 is accordingly disposed of. যদি আমি নাও বলবো তো ওইসব ডিসপোজ সরি
Item number 3 for the state, my lord.
Item number 3, I appear for the petitioners. I was praying for a short passover. I am led by Miss Amrita Bande. She is at her legs before another court, your lordship.
ठीक है
I was humbly praying for a short passover.
short and long I don't
Obliged, your lordship.
but it has been passed over. Yes.
Obliged, your lordship.
Yes, call them.
Lordship, I am for the petitioner. Lordship, on last occasion, that is on 10th of September, Lordship directed OP to OC to intimate the OP2 to be present in the court. And apart from that, we have been directed to serve to furnish our affidavit of service. But as per the last service, the tracking report we obtained today morning only. It is status showing is same. Lordship,
My lord,
maybe that had not been
I
updated.
got an information only from the concerned police station that your revisional application is pending. My lord, I haven't received any copy.
You serve a copy of this revisional application.
Lordship,
Here
I
and
in course of the day, Lordship.
Here and now, yes.
Number 10, you have filed your wakalat nama?
I am filing, taking steps.
Why this application?
Lordship, should I place the facts of the case?
My lord, I do not have any copy, my lord. Let me get a copy.
Yes. Learned advocate. Yeah, petitioner is represented by his learned advocate. However, you are for the
Opposite
private,
party.
private.
Private. No. Copy fine.
OP number 2 is also represented by what's your name? Please hand over your name. And did you file your wakalat number?
He told
My lord, I have received today only. I'll file. I have the wakalat nama with me.
And then by when you will file wakalat number?
In course of the day, today only.
In course of it. Leave is granted to file wakalat nama in course of the day. He submits that copy of revisional application has not been served to him. Learned advocate for the petitioner is directed to serve a copy of revisional application here and now
Lordship, we will get a photocopy of this.
during the course of the day. During in a course of day. You know our key. Then when should I fix it?
By any day. Any day.
Let this matter appear on 19th September under the who is for the state? State के नाम है? Yes.
Lordship, state may be direct.
Vaishali Basu. You are Vaishali Basu.
No, my lord. I am Trisha Rakhi.
Trisha Rakhi. Okay.
State may be direct to bring the case diary on next occasion. Lordship.
I have
If required, this is the
the case diary with me.
business of a state. No direction is required on the state. Under the heading of hearing, parties are directed to complete.
Thank you.
Grateful.
Grateful.
What your place?
Yes. Next. Yes, who is in item number 5?
My lord, I am for the petition.
Yes. What is in this matter?
My lord, in this matter, my lord, I am the husband of the opposite party number 2 here in matter. My lord, after our marriage, some discrepancies cropped up, and therefore the wife has preferred an application and
You have challenged
he ordered
judgment and order dated 14th July
on
2020.
25, my lord. In that, to cut short the matter, my lord,
Mhm.
I was awarded with an interim maintenance of rupees 3,000, which, my lord,
Mhm.
at the stage of final order, was raised to 4,000 for the wife and
What is your profession?
sorry, my lord.
What is your profession?
My lord, I am a volunteer under the, and that is annexed at page number 61. That is my space scale, my lord.
Yes.
I only earn in a month 13,202 rupees, my lord. And now, my lord, in that order, while the court was pleased to grant, allow me to place my affidavit of,
Any child?
yes, my lord, I have been due
Child is residing with
with the mother.
mother.
Now,
Then
my,
4,000 is
no, my lord, what I am on is, while this order was passed, I have challenged this order.
yes.
Now the learned court, they allowed the challenge, whereby allowing me to place my affidavit of assets before the learned court below.
Yes.
Subsequently, there was a delay due to the COVID-19 pandemic. I was unable to pay certain sum of amount and delay in preferring the appeal. Now, my lord, due to this delay, the learned court was also pleased to award me rupees 40,000 as cost, that to be paid within 15 days. Now, my lord, I am earning only I am earning only 13,000 a month.
So you want to suspension of
That cost, my lord.
cost. Okay.
I am duly paying all the areas. I have already paid all the areas. I have certified.
Then we refer the order.
My lord, the challenged order.
Yes, impugned order.
Yes, my lord. My lord, that would be, since their enclosure, my lord, it cannot be paginated, but it starts.
When the cost was imposed upon you.
Yes, my lord. That is, my lord, third last page from the last. Keeping in view the facts and circumstances of this case, I am of the opinion that impugned order dated 1/12/2023 is liable to be set aside only to give the respondent number 1, that is me, an opportunity to contest the case, as he failed to appear and contest the case after COVID-19 period due to his illness prima facie, supported by medical documents, subjected to compensating the respondent number 1 wife, who proceeded before the learned trial court diligently. Thus, this case is remanded back to learned trial court for fresh adjudication, only to give the respondent number 1 an opportunity to
You have no grievance on monthly maintenance amount.
My lord, that I have been paying rupees 3,000 because of this order only.
Already paying.
Already paying.
It has been enhanced to
4,000 part, and I have challenged that part.
Yes.
While the learned appellate court allowed that appeal, but they also charged me rupees 40,000 to be paid within 15
Okay.
days.
Yes.
Since I could not do so, now the
Take down. Learned advocate for the petitioner is present. The judgment and order dated 14th July 2025 passed by learned additional district and session judge 7th fast track court Alipur South 24 Parganas in connection with criminal appeal number 4 of 2024. ये लिख लें Where under learned code set aside the order dated 1st December 2023 passed by learned judicial magistrate 5th court Alipur South 20 Paraganas South 24 Paraganas in AC case number 2670 of 2018 under section 12 of the Protection of Women from Domestic Violence Act 2005 and remanded the case to the learned trial court for fresh adjudication. After giving opportunity to the husband to contest the case by filing affidavit of assets and liabilities, subject to the condition that husband will make payment of all the arrear interim monetary relief as per the order dated 18th December 2019 within a month from the date of that order and also and to payment of cost of Rs 40,000 to the wife within 15 days from the date of the order. Learned advocate for the petitioner referred paragraph number 16 of the said impute judgment and order, wherein the said conditions were imposed. He prays for a stay in operation of (26 and 27), paragraph 26 and 27. কি লিখেছো? Operation of the order in respect to payment of cost of Rs 40,000 rupees to the respondent number 1 wife till the hearing of this appeal. At the submission of upon hearing of his submission and perusal of the material on the record, I find arguable question of fact is involved in this revisional application, which requires hearing and examination. Accordingly, this revisional application is admitted. Learned advocate for the petitioner is directed to serve notice along with the copy of this revisional application to OP number 1 estate through the office of learned PP, and OP number 2 Munmun Das to her residential to her postal address.
Your Lordship, I am appearing on behalf of the opposite party number 2.
Oh,
May I be permitted to serve through the learned advocate?
how notice was served to you?
Client came and told us.
Estate
Another
তারপরে
filing.
ফুল স্টপ দিয়ে দেবো and file affidavit of service by the adjourned date. However, OP number 2 is represented by ওনার নাম লিখে দেবো, give your representation appearance is represented by does this. So notice is not required to serve upon the OP number 2. However, he is directed to serve a copy of this revisional application to the learned advocate for the OP number 2 in the course of this day. Do you have any objection
No, my lord.
in a stay of
No,
submission?
my lord. Let them serve a copy first, then we will give our objection if necessary.
No, he prays for a stay
Yes, my lord.
of, for payment of cost of Rs 40,000 rupees. Do you have any objection?
My lord, let them first serve a copy. We haven't been served with the petition yet. So without the copy, I cannot.
Okay. Learned advocate for OP did not raise any objection on the prayer of a stay to the order of cost to be paid to wife within 15 days of the impugned order. Let the order for cost is stayed till second week after the puja vacation. However, parties are directed to come prepare on the next date. Let this matter appear on 19th September under the heading of for filing of affidavit of service.
My lord, the next date is
19th,
September.
19th, yes.
Deeply obliged.
You have to conclude your submission
Yes, my lord.
before the expiry of period of stay. Otherwise, I will not grant any further extension to the.
I will, my lord.
Yes. Take all necessary steps
Yes, my
in
lord.
the meantime.
Deeply obliged.
And you prepare yourself.
Yes.
Good.
Item number 6. Yes. I'm for the petition. I'm before your lordship for quashing of the impugned charge sheet.
ये सब नया वाला बनाया ना Yes.
Lordship, I am before you for quashing of the impugned charge sheet filed by the police against the petitioner under section 323, 324, 326, 307 and 34 of the
Why you
the thing is that in
raise?
this matter, two separate incidents occurred in different times, different place, clubbed together in a single FIR to start the case against these petitioners. And there is case and counter cases there.
Yes. That
So-
is matter decided by the trial court. These are the disputed question of fact.
No. The thing is that in my case, police doesn't file the charge sheet, and in their case, they have filed the charge sheet against us. So the LCR requires to be placed before your lordship.
Okay. Yeah, take down. Learned advocate for the petitioner is present and submits that he prays for quashing of charge sheet number 5 of 2024 dated 6 January 2024 submitted in connection with Chitpur Police Station case number 119 of 2023 dated 28 August 2023 corresponding GR case number 2062 of 2023 under section 323, 324, 326, 307 of 734 of IPC. Corresponding BNSS আছে সেটা লিখে নেব। Presently pending before the Court of Learned ACGM, Sialda South 24 Pagnas, and all subsequent proceedings on the ground that two separate incidents were happened. When the incident was happened?
It was happened, my lord.
Happened
On 27th of 27th of August 2023.
on 27th of August 2023. But both has been clubbed together, which is patent irregularities in the face of the proceeding. He also submits that case and counter case is pending. Upon hearing of his submission and perusal of the materials on record, I find there is debatable question involved in this revisional application, which needs to be decided by hearing. Accordingly, this CRR 3231 of 2025 is admitted. Learned advocate for the petitioner is directed to notice wala diya do dono ke.
Kindly call the LCR. LCR is required to be placed.
First, let the state be appear. To whom should I give direction? You file কি direction দিয়েছি to issue notice. You just issue notice upon both. How many OPs are there?
There are
1 and 2.
1 and 2.
On both OP and file affidavit of service on the adjourned date. That would be 19th, a week after. And thereafter will pass more direction if necessary. Yes.
My lord, I beg to appear on behalf of the petitioner, my lord.
Yes.
What happened in this case, my lord, is smuggling of red sandals were going on. That is red sandalwood in the year 2016. My lord, a 14,790 kilograms of red sandals, or that is red sandalwood, was smuggled, amounting to rupees 6 crores 65 lakhs. Investigation in that respect was carried out.
Sandalwood?
Sandalwood, red
Where?
sandalwoods.
From where? Smuggling from south.
Yes, through Kolkata to some other places. So
Yeah.
that was intercepted, that was caught. Investigation was carried forward.
Yeah.
Investigation was done under the Customs Act, since the seizure was made under the Customs Act. Now, my lord, a show cause notice was caused to be issued. A show cause notice was issued. After further investigation was carried out, a supplementary show cause notice was issued. While carrying out further investigation, we saw that some of the officers of the Customs Department itself are involved in the said smuggling activities.
Maybe.
Therefore, those officers were also implicated in the supplementary show cause notice. One of such officers, that is the opposite party herein, challenged the said proceeding under the Customs Act and came before the Honorable High Court, challenging the show cause notice. This matter was heard by the Honorable Division Bench, presided by the Honorable Chief Justice. Honorable Chief Justice held that the proceeding that was going on pursuant to the show cause notice will go on, and that is a proper proceeding. Lordship kindly comes to page 32 to 50. 32. This is the judgment passed by the Honorable Division Bench, presided by Honorable Chief Justice, wherein the challenge to the show cause notice in respect of this red sandal smuggling was filed before this Honorable High Court. The entire investigation proceeding was upheld with a further direction that investigation must go on.
Then
now, Lordship, investigation was carried forward again, and it culminated into filing of show cause, and thereafter adjudication order was passed. Adjudication order, my lord, it was held by the adjudicating authority that smuggling has taken place, and necessary order against the persons were also passed, including necessary orders against the opposite party number 1. That is by way of imposition of penalty.
Where is the order?
Lord, I will show to your lordship.
Okay.
Now, lordship, what has happened parallelly, since those persons were found to be involved in smuggling activities, departmental proceeding was also initiated against opposite party number 1. A departmental proceeding, my lord, issued a show cause notice. Lordship kindly comes to page 52.
Yes.
This is the memorandum of charge sheet. Lordship kindly sees the charge sheet. Kindly peruse it, lordship. Now 54, 56, 58 onwards, these are quite a big number of pages, wherein it has been clearly stated how they have acted and what they have done. Say, for example, lordship kindly comes to page 55, Article 3. That Sri Shondip Kumar Dikshit, superintendent such and such, engaged himself in smuggling of prohibited goods, tampering with material facts related to the case, manipulating evidences, forging central excise and customs documents, etc., etc. Now, this proceeding also carried forward and was held. Major penalty order was passed against the opposite party number 1. Now, lordship, what has happened, as by way of an afterthought, the opposite party number 1 lodged a complaint before the competent court under section 156, levying all kind of vexatious afterthought and and allegations which doesn't stand at all.
Yes.
Now, lordship, I humbly submit before your lordship, my lord, this is nothing but an afterthought. Since he has been implicated in a proceeding under section 124 for smuggling and the departmental proceeding under the administrative head, so he has done this in a revengeful manner. And against whom, lordship? Against the officers of the department who were involved in the investigation at that point of time. Now, the learned court below, without appreciating these background facts, without appreciating the provisions of law, that Customs Act is a special act and CRPC and IPC will not apply. Moreover, under section 155, which is my duty to show before your lordship, under section 155 of the Customs Act, the custom officers enjoys a immunity. Immunity from any kind of action in respect of the actions taken by them in their official capacity. Overlooking all such things, without assigning any kind of reasons, the learned court below passed an order that FIR is to be registered against the officers. Now, one of the officers retired as a additional additional director general of DRI Kolkata. Now, he has been appointed and nominated as a judge of the GST tribunal. He is going to take charge very soon, lordship. Now, these have been done against them by the opposite party number 1 as a personal vendetta against those persons who carried out the investigation against opposite party number 1. Now, the whole intention is to malign the department and malign the officers who have investigated against him. Now, Lordship kindly sees section 155 of the Customs Act 1.
Yeah, Custom Act.
Lordship, may I read it and hand it over to your Lordship?
Yeah.
Section 155. Section 155 very clearly says, subsection 1, that no prosecution can be filed against the officers of customs who have discharged their duty in official capacity. Lordship kindly takes the trouble to see section 156, subsection 1. No proceeding, no prosecution, no suit will lie.
156.
156, subsection 1.
Yes.
155.
Without.
The learned court below, without seeing into this provision, totally overlooking it, being oblivious to this provision, has passed the order.
Yes.
Which is in a way demoralizing the working of the department. No, Lordship kindly sees 6 crores was the amount of smuggled goods. 14 kg of red sandalwoods were smuggled. And this is the racket which was busted. And the officers have gone against this racket, international racket, and have done these great steps in the for protection of the economy of the country.
So you have challenged those.
The order. Yes. Lordship kindly sees the order. Not even a single word of reasoning why
Where is the order
has been passed.
Where is the improved order?
Yes, Lordship kindly sees the order dated 23/6/2025, the last page of the certified copy. No discussion, no assignment of reasons, no finding, nothing. And moreover, overlooking section 155. And without considering that Customs Act is a special act, and in view of section 5 of the CRPC, Customs Act will prevail over CRPC. Lordship kindly sees the last page. May I find it out for your Lordship, my Lord?
Just a minute.
The last page, my Lord, the last page. May I find it out, Lordship? Lordship, we have flagged it, Lordship, kindly.
Yes.
Lordship kindly takes the trouble to go through the order, Lordship. There is not even a semblance of reasoning, no finding, nothing in the order. Just a mere report has been filed, no discussion regarding the report. What is the content of the report? Nothing. Prima facie, this is a bad order, which cannot stand the scrutiny of your Lordship.
Where is the charge sheet? Hey, where is the FIR?
FIR is at page, Lordship kindly comes to page 1110. The only intention of filing this application before the court below is to get out of the rigors of the Customs Act and the
What are
Department
the
of
allegations raised against you?
Yes, Lordship, the sections are at para number 13. And none of the sections are applicable. And Lordship kindly sees a slipshod manner in which it has been dealt with. In every matter, your Lordship takes trouble to assign reasons. Here, no reason has been assigned while passing the order. And in such an important case.
Yes. Let me admit this revision.
My Lord, I'm grateful.
Revisional application.
And Lordship kindly protects us for a limited period.
What
Kindly-
sort of protection?
Kindly stays the operation of the order for a limited period. Let me serve and come back.
What is
Because FIR has already been lodged and steps may be taken by the police authorities against us. And we are public servant, Lordship. We are holding officers of customs. And one of us has been selected as a judge of this GST tribunal. And we have discharged our duty while being in official capacity. And the immunity under section 155 we enjoy.
What are the allegations raised against them?
Totally absurd allegations, Lordship. The allegation is...
Where is the complaint? 156
Yes.
complaint?
Lordship kindly comes to say page 128, which is not supported by a responsible affidavit also. Mere allegations that while carrying out investigation, some of the CDs were doctored. Yes. And Lordship kindly sees page 129, offences committed. During course of investigation, it is the prerogative of the investigating officer and the investigating agency how they will conduct the investigation. It cannot be dictated by the accused. This is exactly what the accused is trying to do. Since an adjudication under the Custom Act has been passed against him, since departmental proceeding has been passed against him, punishment has been leveled against him, now he wants to turn around and to...
No, accused is not prohibited not to bring prosecution against the complainant if complainant do anything against his interest. He can lodge a complaint against you. Where is the prohibition?
Lordship kindly see section 155. The prohibition is there. 155 Customs Act. No proceeding, no suit, nothing can be initiated against the officers.
In connection with
with the
Customs Act.
Customs Act. In connection with the official...
But in connection with IPC,
now,
he is free to lodge a complaint against you.
Lordship kindly
Where is the prohibition?
Very well, Lordship kindly stays it for a limited period. Like Lordship kindly protects us for a limited period. We shall come back.
That is another matter which can be considered.
Kindly considers it.
That's why I am insisting you to tell me what allegations he raised against you.
Only pages have been filed making no allegations. It is only a method to scuttle the orders that have already been passed against him, which I have shown to your Lordship. The adjudication order against him, as well as the departmental proceeding that has passed against him. Just to overreach all those proceedings, he has done so. And he has questioned the investigation, method of investigation.
What is the
allegation? Is that the DVDs at the time of investigation was manipulated.
What is DVD?
Data, that's a data collected in the DVD form. And those were all tested by the laboratories, forensic data. And forensic laboratory has returned a report in our favor. And proceeding is continuing, and proceeding has come to an end, which we, and the said proceeding, there is an order against the opposite party. Now, Lordship,
his allegation is only in respect of the proceeding and procedure adopted by...
Yes, which he cannot question.
There is no any allegation
Nothing
of IPC.
No.
Lordship, may I submit something? I am complainant in this case.
So who is your learned advocate?
No one is. I am representing myself.
In person?
In person.
Then not required to serve notice. Who is the other side? OP? Only... Yeah. Only one OP is there.
Yes, only one OP.
Yes.
Basic fact is that...
Just a minute. Take down. Learned advocate for the petitioners is present and submits that opposite party is a employee. What was your designation there? Is superintendent?
Yes.
Yes, Your Lord.
In custom department.
May I say submit something? Your Lord?
Just a minute. I will give you opportunity. Just a minute. In custom department, who was engaged in a smuggling of red sandal, use quantity of red sandal amounting 6
crore 65 lakhs.
6 crore 65 lakhs. Accordingly, a proceeding, departmental proceeding,
Accordingly, my lord, proceeding under section 124 of the Customs Act was initiated, and
accordingly,
departmental
a
proceeding was also
proceeding under section 124 of the Custom Acts was initiated against him. One departmental proceeding was also initiated against the OP. What was the outcome of departmental?
major penalty was imposed.
Wherein major penalties was imposed upon him. What was the penalty? Major penalty?
Reduction in rank as well as
Major penalty.
Objection, Your
That
Lordship,
is
not reduction in
reduction.
rank.
reduction in pay scale.
Just a minute. You please take your seat. Reduction in rank. and
Reduction in pay scale.
Reduction in pay scale. And what was the outcome of 124?
124 order in original was passed against him.
And the proceeding initiated under section 124 of Custom Act was also ended, was also concluded against the OP number, against the OP. Yes. Then, out of vengeance, he lodged a complaint under section 156(3) of CRPC before the learned CGM Calcutta, upon which where is the FIR?
Already FIR is at page
110, yes.
10.
Wherein he directed which police station it is?
Shakespeare Sharoni police station.
To IC of Shakespeare Sarni Police Station, Kolkata, to lodge a case under section 166A, 169, 420, 465, 469 of which act?
Of the IPC, my lord.
IPC?
Yes, my lord.
Not visible.
Lordship kindly comes to page 111. Section
Of
150.
IPC.
Lordship. Top.
B लिखे जो था 166A, 167, 420, 465, 469, 471, 120B of IPC against the petitioners.
Hang on.
He submits that this proceeding was initiated only to malign the petitioners and the department, petitioner who engaged in busting a racket acting behind a smuggling of red sandalwood. Yeah, red sandal. he also maligned the you chair the OP Sandeep Kumar Dikshit appears in person. Yes, now you tell.
Your Lordship, in this case, they have seized a DVD that was containing 45 files folders at the time of seizure. On seizure date is 29th July 2016. Thereafter, they have issued first show cause notice on 26th August 2016, wherein there is no mention of that DVD or no mention of myself as.
These are the
Proceeding.
disputed question of fact and
Let me submit something, sir.
yes.
Thereafter, they have prepared its forensic copy in their own office on 18th January 2017, and that forensic copy has been provided to me. That forensic copy contains only 44 files folders, and that forensic copy is prepared on the creation timing is shown as the date of seizure. That is 2:30 a.m. of 29th July 2016. This is the basic fact. They have seized the DVD containing 45 files folders, but they have not brought on record that DVD in any proceeding, sir. They have brought.
Did you challenge those proceedings?
Yes, Your Lordship, and in that proceeding, I have exonerated by C-Stat. That fact has been suppressed by him. I have exonerated in those proceedings on merits by Honorable C-Stat. That is the fact of case. I have made complaint in the year 2018, not after passing of the OIU.
You have made complaint on?
I have first of all made complaint on 10th October 2018 to Cyber Crime Cell, Calcutta Police. Thereafter, they have transferred those applications to Bhavani Bhavan.
You have made complaint to different agencies and authority.
Prior to that,
after you have been implicated in this case.
Yes.
Prior to that, you didn't make any complaint to anywhere.
Prior to that, while they have recorded my statement in the RI office, I have challenged the veracity of the DVD. During course of investigation, I have challenged it.
What is your authority to challenge?
They have sought
what
my
authority you have?
They have sought my voice sample. I have said that due to legal issues and due to personal
Everything has been decided. Everything has been decided. You challenge those proceedings before the appellate forum or competent forum.
That from appellate forum, I have won the case, Your Lordship, on merits.
Then,
and in
then
this case,
why you lodge complaint under section 156
because
for
of
the CGM?
Because of these, they have initiated entire proceeding on the basis of documents shown to be recovered from that DVD.
You are still working in that department. Where is your present place of posting?
I am currently posted at C-Stat as superintendent here, and currently this case, due to this use of a forged DVD against me, I have suspended 4 years. Thereafter,
out of vengeance, you started to harass them.
No, my lord. Because they have seized the DVD of 45 files folders.
Indeed. If any information would be wrong, then
of course, Your Lordship,
would be passed against you.
Of course, Your Lordship, I am ready.
These are not a place where.
Of course, Your Lordship, I am ready.
Let him file affidavit in that case, Lordship.
They have
direct him to file affidavit in opposition.
One more thing, Your Lordship.
Yes.
While passing the order in original, learned adjudicating authority has specifically observed the discrepancies in the DVD and declared it as inadmissible evidence.
What is the evidentiary value of DVD?
It has its own value, Lordship, and it is not only that.
Let me finish one more line.
There were voice samples. Now, Lordship, the adjudication order was passed not merely on the DVD. It was passed on the basis of other incriminating documents, other incriminating evidences also. And the most important factor is, Lordship.
Who is the appellate authority?
Appellate authority is C-Stat.
And from C-Stat, I have won the case.
Did you challenge this order before?
Yes, Your Lordship, and I have won the case from C-Stat. 10th July 2025 order is there.
The thing is that the most important point is section 150 of the Customs Act, Section 155 of the Customs Act gives me immunity from any kind of action, any proceedings, any criminal actions,
But
which
that
the,
is for
which was never brought before the learned court below. Which that attention of the learned court below was never brought for in
Yes.
Section 155.
Your Lordship, but that is for the any action done in good faith.
Nothing, Lordship.
He submits that
He being a custom officer, it was his duty to bring it on
he
before the
challenged
notice to the
the
court, Section 155, which he has not done.
They have
He
equal
submits
opportunity before the
that
learned court to present all the
order of
facts.
adjudicating authority has already been challenged by him before the appellate authority, where he got order in his favor. He further points out is certain what is in DVD. What is your complaint?
DVD at the time of seizure contains 45 files folders, but they have manipulated it, converted it into 44 files folders DVD, and implicated me. That is the grievance.
He points out manipulation in DVD, which was the important piece of evidence.
And later on, that DVD has been destroyed by them in their own custody when CBI has sought these. This is one additional
Upon
point. Your
which
Lordship.
the order against him was passed, and said DVD has already been destroyed by the department. After hearing of both sides and considering the materials on record, I find arguable question is involved in this revisional application, which need exhaustive hearing. Accordingly, this revisional application is admitted. Since OP is physically present, and would you like to appear in person?
Yes, Your Lordship.
And prays to appear in person. Learned advocate for the petitioner is exempted from service of notice upon the OP. However, he is directed to furnish a copy of this revisional application to the OP by the adjourned date. Let this matter appear when?
Lordship, as your Lordship will direct, after puja vacations.
How much time you need?
Your Lordship, minimum 1.5 month, 1 or 2 months, as Your Lordship may be pleased.
1 and 2 months is
Because parallel proceeding is running in the CBI court, and I am in process of filing discharge petition. So I need some time.
he is admitted. Let this matter appear after Mr. SEO. Should I fix it after any date after 26? After 2 weeks of the puja vacation, before the bench having determination
Lordship, kindly pass some interim order protecting us, Lordship.
Where is your prayer?
Lordship, yes, it is there. Lordship,
Okay.
kindly comes to page.
Hey, the
Page 30, Lordship. I have made the prayer.
learned advocate, do you have any objection? Learned advocate for the petitioner. Where is your prayer?
Page 30, my lord. 30.
30.
Your Lordship, let the investigation may be carried out by the police authorities because it is a very serious issue.
Learned advocate for the petitioner prays for an order to stay the operation of the impugned order dated 23rd June 2025 passed by learned Chief Judicial Magistrate Calcutta in complaint case number 68 of 2021 and FIR number 98 dated 26th June 2025.
Yes, yes.
PS case number
GR
98
case, Your Lordship.
dated 26th June 2025 under section. ওই সব under section থাকবে। But here you have mentioned C.
Lordship, it's a complaint
Dash
because
case.
complaint was lodged. That's why it has been directed to be registered.
Then I am uttering the same what
Yes,
you have
yes.
written here. You didn't write here any GR, didn't give any reference of GR case.
There was not even in the order sheet. That's the reason, Lordship.
Then, which is not here, how can I add
No, we have
my
referred it
own
from page
beautiful.
111 from the FIR. Page 111 of the
No,
FIR.
I am not
My
on the FIR, I am on your
Yes, I'm
application.
grateful to you.
Till the adjourned date. Or ওনার প্রেয়ার আছে let the aforesaid proceeding be stayed till third week after the puja vacation or further or until further order whichever is earlier.
There is one very small prayer, Lordship. We have made another application for impleading DRI because those officers were acting for DRI to make DRI as a party in the proceeding.
You may move this matter before the.
I'm so grateful to you, Lordship.
Thank you.
ওইটা দেবেন দাদা।
ওখানে একটা লাইন আর দিয়ে দাও ये learned advocate for the petitioner behalf he referred section 155 subclause 1 of the Customs Act
1962. Yes.
In support of the immunity of the staffs of the Custom Department from any prosecution.
Your Lordship, my prayer should also be noted because they have not acted in good faith.
Already I have noted.
Because they have seized one item and brought on board another item.
You have no locus right to be heard.
Right, Your
You
Lordship.
will be heard later. একে দিয়ে দাও 155 subclause. Yes.
I'm so grateful to you, Lordship.
Oblige, Your Lordship.
Yes.
Possible.
Next.
Possible matter may be taken up. I have to go.
Not now.
Item 3.
Not now.
Not now. Not
Please
now.
wait. After 33. After 33. We'll take up it as.
I beg to appear on behalf of the petition. Petitioner is the wife before your lordship. There is a section 5 application also. 11 days delay. Matter is relating to 125 proceeding.
Why? What is the reason of delay?
Since she was not getting adequate maintenance, her arrears has been stopped by the order of the learned sessions judge. That is why I prayed for setting aside of that order and the revisional application through which the opposite party husband prayed for stay in a execution case that is also pending. Lordship may kindly see the last page of the
No,
order.
what reason you have stated in your application under section 5,
Yes, Lordship.
but you come to your application,
Paragraph number
it is not as
paragraph number 5, Lordship may kindly see 4 and 5. 5 is the relevant.
economic destitution of the filing application. Financial hardship was
Yes, Lordship. Because only 2005, 3000 was first interim maintenance was granted by
Yes.
the magistrate. That thereafter
take down, take down. Crane 1 of 2025 is an application under section 5 of the Limitation Act for condoning the delay of 11 days in preferring the instant revisional application. CRR 3243 of 2025. Learned advocate for the petitioner refer paragraph number 4 and 5 of this application to explain the cause of delay. It is stated therein that due to financial hardship, the delay has been caused in preferring the instant revisional application. The explanation is sufficient and delay is condoned. Accordingly, Crane 1 of 2025 is disposed of. Yes. Now you come on your petition.
Lordship may kindly come to page number 25. This is the first order passed by the learned Additional Chief Judicial Magistrate, Barasat, North 24 Parganas.
Page number 25.
Yes, Lordship. An ex parte order was
No
passed.
pagination is there, sir. No pagination. What document you intending to refer?
Order dated, Lordship, 3/6/2022. That is the first ex parte order.
3/6/2022.
The order passed by the learned Chief Judicial Additional Chief Judicial Magistrate.
Yes, yes, yes.
He granted interim
3/6/2022. Yes.
the
Ex parte order.
yes, Lordship. I was granted 3000 interim maintenance.
Who was the petitioner there?
Wife is the petitioner.
OP.
Here.
Here in this case, 125.
Yes, Lordship. The wife is the petitioner in her, and I'm the wife in this revisional application also.
Just a minute. And wife is petitioner here.
Yes, Lordship.
And she has filed an application under section 125 of
CRPC.
CRPC.
Yes, claiming
Yes.
maintenance.
What happened here?
Here, Lordship, by an order dated 3/6/2022,
Yes.
learned Additional Chief Judicial Magistrate passed an interim order of 3000 per month.
Yes.
And the OP is directed to pay 3000 per month to the petitioner with 10 days of each succeeding month, for which it becomes payable and dues.
Yes.
The order is effected from the date of filing of this petition.
Yes.
21st February 2020.
Yes.
My lord. Thereafter, the opposite party husband challenged that order. And
Where?
the learned sessions judge reduced the amount to
And you have challenged that.
no. That I have not challenged. Reduce the amount to 2,500, but the other conditions remain same.
Yes. What are the other conditions?
Cleared the dues,
Huh?
payable and dues, the dues portion. My submission is the due is indicated because of the arrears.
Payable and dues.
Yes, dues means my submission is that is arrear because it is payable from 2020.
Yes. The dues has not been cleared till now.
No, Lordship. Because of the.
Where is the order of appellate court?
Lordship, may kindly see the last page of my petition. I filed an execution case that has been stayed, and the order passed by the learned sessions judge. The order passed by the learned additional chief judicial magistrate Barasat on 26th March 2005.
Yes, this is the order.
It has not cleared. It has only stated to pay 2,000.
Execution case has been stayed.
Yes, Lordship.
Till 10th February, 10th April 2025.
This application is still.
What happened on the 10th April?
Nothing. Till date. Next date is fixed.
Where is the order of that adjourned date?
Because 31st October is the next date fixed for hearing of this revisional application. And this by this order, the
revisional application means
in which the order has been passed.
Oh,
this application
this revisional application.
Yes, Lordship.
So
previous revisional application 70 of 2000.
Only miscellaneous execution case number 158 of 2023 was stayed till 10th April on condition of payment of yes, then
only rupees 2,500, but the arrears
till the disposal of this case,
the arrears have been stopped.
Yes, this is interim order.
Actually, the application is still date pending, and
you may take a step there for expeditious hearing.
Lordship, unless there is an order from your Lordship, nothing will happen.
No order could help you.
Yes, Lordship, that will help. Because the order itself.
What is your prayer? What you want?
This order is contrary to the earlier order of the learned sessions judge, which was passed in criminal.
Learned sessions judge is sitting in revisional jurisdiction.
But Lordship kindly sees both the orders.
And this is not final order. This is interlocutory order, interim order.
Yes, Lordship, but kindly sees.
You cannot challenge interlocutory order.
See, an application under section 482 I have challenged.
Not
because that is affecting my right to get arrear.
It is better to go and place your matter there.
I am ready to place, but kindly direct them to take up dispose of the matter within a specified period.
Such type of direction,
because this is matter related
is
to
not healthy in the eye of law.
That will help because this is a matter of.
Let them do their work. They are also judged, and let them do their work.
Otherwise, adjournment will be granted.
And you are advocate. You have all
that is why, Lordship, I am approaching
power to get access and make prayer. You make your prayer there. Certainly, judge will consider.
We are agreed. We are ready to make the hearing, but they are avoiding because they are trying to avoid to be paying.
You may pray for adverse order. Huh? You may pray for adverse order. If they will avoid, how long they can avoid? How long?
That is why, Lordship, I am praying for an order for expeditious disposal.
Do you think that by the order of this court,
yes,
OP will be so diligent to appear there on every day?
Even they evade, the court will pass another expertise order against him. Because the first order was expertise.
Prayer is
avoiding.
What is your prayer? Let me see. Call for record. Pending disposal of STM. Quashing of the impugned order, first priya.
Yes, Lordship.
Direct Topi party number 2
And kindly
to
see
pay entire area.
prayer C.
Direct to expedite hearing. Take down. Learned advocate for the petitioner praise for and direction, a direction in respect of prayer number C. For expeditious hearing and disposal of criminal revision number 70 of 2025 pending before learned additional district and session judge, 5th court, Barasat. Considering the innocuous nature of prayer, learned trial judge का गोटा ही दिए देवे description, is directed to take necessary step for swift disposal of the hearing of the pending revisional application as early as possible. Other prayers. Oh, we'll share the other prayer problem. Accordingly, this revisional application is disposed of. There is no order as to that.
No unnecessary adjournments be given to the either party. No unnecessary adjournments be given to the other party.
As early as possible,
Kindly.
without granting any unnecessary adjournment. Okay, note करो now, without granting any unnecessary adjournment. Okay. তোমাকে বলছি without granting any unnecessary adjournment ওখানে appropriate জায়গাতে ঢুকিয়ে দেবে. Yes.
Okay.
Yeah. Yes.
I'm on behalf of the petitioner. Petitioner lodged a complaint before Larned CGM Asansol. Larned magistrate was pleased to send that to the Hirapur police station to treat that as a FIR lordship under section 156 subsection 3. Police what have done lordship, put lesser section lordship, though there is ingredient of 307, police has not inserted this section lordship. Your lordship kindly come.
Did you raise this question before the CGM? The magistrate
CGM stated lordship. Your lordship kindly come to the impugned order. Last page of the petition lordship. Larned magistrate lordship, type copy is there lordship. Larned advocate for petitioner defective complainant on the ground that few sections shall not be taken into account. Registering this case. However, same was noted on the original written complaint, and for which she being aggrieved to the effect caused to COVID the relief as to why those sections was removed. On perusal of the order dated such and such, granted by Larned CGM Asansol, had specifically ordered that the complaint requires to be registered as an FIR without being influenced by the quoted section of the complaint. But lordship, here specific allegation in the FIR, lordship. This is true.
Then what is the procedure?
Procedure, lordship, police station must go through the complaint, lordship. Your lordship kindly come to the complaint.
If police officer did not follow the procedure, then
Then Lordship, I went to magistrate, learned magistrate rejected that.
did you knock the door of learned magistrate in this
Lordship.
respect?
I knocked the door, Lordship.
Where is the order? What step you had taken before the learned magistrate?
Magistrate rejected my application, Lordship.
Where is the order?
It is last page, Lordship.
Oh, this one.
Type copy is there.
Heading section and heading section and
Record is put up for the petitioner on the ground stated by the learned for the on the ground. Objections shall not be taken. Investigation concluded. Charge sheet submitted. Charge sheet.
No. Just FIR as Lordship. Charge sheet has not.
Let them submit their charge sheet.
Lordship, let me.
You may pray for further investigation. You may pray for direction.
That is true, Lordship. But as there is lesser section, Lordship, the opposite party will get the bail, Lordship. The accused person will get bail.
These are not the matter to make you.
Lordship,
these are the juris.
Specific, if your Lordship come to the complaint.
What is your prayer?
My prayer, Lordship, to. I'm coming.
An interim order of a stay of the impugned order.
And that is my interim order, and my I want Lordship to put the section.
Still,
let them. Lordship,
still, the matter is under the investigation.
Lordship.
And you know, at the stage of investigation, court has no role to play.
But
whatever the role could be played, it is the proper forum of the magistrate. You should wait till submission of his charge sheet, and you may file Naraji petition.
Yes, Lordship, scope is.
Where is your Naraji petition? Did you file?
After charge sheet, I can file, Lordship. Prior to that, I cannot file charge sheet.
During the course of investigation, you may file. You may file if you are not satisfied with any step taken by the IO, you may bring those irregularity to the eye of the magistrate.
Lordship, I brought notice to the magistrate. Magistrate has not allowed my prayer. Magistrate rejected my prayer, Lordship. And if I have to file Naraji petition, that is, Lordship, after charge sheet.
Then what do you want from this court?
I want, Lordship, let me serve. And if there is ingredient, Lordship, in the complaint and as well as in the 161, let the section be inserted, Lordship.
Who will insert?
Lordship, your Lordship will direct.
No. How this proceeding was initiated? Upon
156, upon the complaint of the complainant, learned magistrate sent it to the Lordship OC Hirapur for investigation under section 156, subsection 3. Thereafter, the case started, Lordship. Now the police started in a lesser section without going through the complaint. They have not inserted the section 307. So there is ingredient, Lordship.
yes, learned estate. Enlighten me.
My lord,
What
prior
sort
to
of
filing charge sheet, there is no scope. My lord, the investigating officer will investigate the case. If he finds there is some materials, then he will pray before the learned magistrate for adding section. And my lord, with regard to his submission, that police is not investigating properly, there is separate forum, my lord. He would file the, my lord, police in action before the residuary bench.
Exactly. Revisional jurisdiction.
What I am telling,
Your
Lordship.
lordship cannot add any section right now here by passing on.
I am not telling that, Lordship. Let me serve copy, let the CD come, and if there is ingredient of 307, it will be included, Lordship. I am not saying right now, Lordship.
My lord, investigation is going on.
Yes.
Yes. Not yet come.
Considering the CD, how can your lordship
It is
Lordship, if
your
there
application is infructuous.
Lordship, if there is ingredient of 307, that must mean your Lordship kindly come to, for my satisfaction, your Lordship kindly come to
Sir,
para
you
five.
know very well.
Portion of para 5, your Lordship kindly come. Last portion of para 5.
You
Specific
have
allegation.
made this application under section 401 and 482.
Lordship.
Where is the irregularity? And
Dear Lordship,
these are interlocutory orders, sir. What right has been?
Lordship, that police started in a lesser section. They have not inserted the section
You
of
raised
307. Though there is
no this is
ingredient of 307,
take down.
Lordship.
Take down. Learned advocate for the petitioner. Praise for quashing of the order dated 16th June 2025 passed by learned CJM
Asansol, Paschim Bardhaman.
of Paschim Bardhaman in Hirapur Police Station, case number 136 of 2025, dated 1st May 2025, corresponding GR number 1151 of 2025 under section 136. ये सब देखें लिखे लगे. Pending before the learned CJM, Paschim Bardhaman, Asansol. What is lesser section? Lesser section means?
Lesser section, Lordship, 307 they have not incorporated, Lordship. And Lordship, one section, I'm telling you, your Lordship can come to para 5 of my application.
Yes. He referred paragraph number 5 of the revisional application.
Lesser section 119(1) of the BNS. And lesser section, Lordship,
191.
subsection 2 of BNS. Lesser section 119. And actual section, Lordship, 115.
Wherein he stated that in lieu of 119(1) of BNS, IO added lesser section being 115(2) of BNS.
Lordship.
My lord, one indulgence.
Yes.
My lord, kindly see the order passed by the learned CJM. Last portion, my lord.
Yes.
What the learned CJM has opined, my lord.
On perusal.
Without being influenced, my lord, the petitioner can submit, while drafting, my lord, he has put certain sections.
Not section, ingredient is there.
No, you cannot instruct anyone to.
My lord, the authority
start
authority will consider, and my lord, he will, my lord, accordingly put sections. My
Lordship, what I am submitting, if there is ingredients, Lordship, section should be inserted.
You cannot say. You cannot say.
So they have to start the
You have opportunity to contest on every step, but this is not proper proceeding before you.
Lordship, I can file Naraji petition after submission of that is true.
Yeah.
But right now I have came, Lordship, for this reason that
you may
section should be inserted.
Such direction cannot be.
No, Lordship. What I am telling, Lordship, if there is no ingredient, they cannot say so. But
let them do their work. Na? How can you compel them to initiate proceeding under this section itself? How can you say, sir? You are so senior, you are well aware about the provision of law.
There is ingredient that they do not insert. That is my only. I have.
Let them do. Let them do.
Filing of charge sheet.
He may file charge sheet under this section.
Let him wait whether these sections are added or not.
This is premature to raise any allegation against anyone. Na? They are doing their job. They initiate proceeding under section 115, but it may they may file submit charge sheet under section 119.
But Lordship, really I came before your Lordship for adding the section 307 because there is ingredient, Lordship, specifically stated with a view to murder.
Let them do their work. They are the competent authority.
Oh, I am leaving it to your Lordship.
They are competent authority. দেখে অনুভব দেখো কি লিখেছো ঠিক আছে he further submits that this proceeding was initiated on a retained complaint of the petitioner filed under section 175 bracket 3 of BNSS, which was sent to the police station for registration of case and initiation of investigation. But police initiated case under the lesser section despite ingredient for registration a case under section 119 bracket 1 of BNS. He filed a petition before the Court of Learned CJM, Paschim Bardhaman, who passed order on 16th June 2025 wherein his petition was rejected due to lack of merit. Upon hearing of submission and perusal of the material on record, I find that this petition, application is premature and not sustainable in the eye of law at this stage. So, therefore, this application is dismissed. There is no order as to the court.
The state submission may be recorded.
Learned advocate for the state. What is your submission? Who आगे कर देबे? माने after petitioner? For record. Yes. What is your submission?
First of all, my lord, this is premature.
Yeah, premature.
My lord, secondly, my lord, there is no scope to file such application before your lordship for adding section.
This is premature, that's. In that situation, I have to enter into the merit of this case. Not required. ওনার নামে দিয়ে দেবে কি learned advocate for the state submits that this application is premature and not and could not be entertained at this stage because investigation of this matter is going on. Yes.
Milord, I have indulgence.
Yes. Indulgence. No indulgence.
No, Milord. I want to withdraw one proceeding item number 103, Milord.
Wait, sir. Not come and start to move in the midst of the hearing. Moving hour is in the bonding hour, na?
Milord, I have some.
Item number 10. Number 10, this is my application. Matter under detectively, I have sent before the learned court the return of my vehicle. Return of my vehicle. My lord,
Your vehicle, why your vehicle has been seized?
My lord, my vehicle has been seized, my lord, due to my lord, contraband article has been recovered from my vehicle. My lord, total 1 kilo.
Did you make any prayer before the trial
That
court?
has been rejected, my lord. I challenging that order. I came before you.
Why your application was rejected, sir?
My lord, without any reason, my lord, my lord, I have challenged that order.
Where is the order?
My lord, there is last part.
Last part of?
My lord, order dated, my lord, 23/5/2025. A stereotype order. As per the my lord latest judgment of the Supreme Court, I can produce my lord Vishwajit De. My lord, if my lord that is not within the knowledge of the owner, that my lord the court cannot allow the confiscation of the vehicle. And in this case, my lord, I have no knowledge about the my lord selling of contraband article in the while my lord granting the anticipatory bail by this honorable High Court. Because my lord, I have no knowledge that time. There was a my lord agreement between me and another person. My lord, that person also my lord make an agreement to them, and my lord that part my lord they have selling of contraband article by using my car, and that's why my lord my vehicle was confiscated. In this regard, I just praying before your lordship, my lord, kindly direct them to serve a copy upon the state and fix this matter.
When your vehicle has been seized, what is the date of seizure?
Yes, my lord. My lord, 31st January 2025.
What is the stage of investigation?
The investigation has been completed, charge sheet has been submitted. And other co-accused person from their custody, my lord, has been, my lord, the contraband was recovered. They have obtained bail by this honorable High Court. And my lord, in this regard, there is a judgment of this honorable Supreme Court also. If my lord grant me sometime, I can produce that judgment also. Because this fact, my lord, is not within my knowledge.
You are owner.
I am owner, but my lord, I made an agreement also.
Hmm.
My lord, kindly come.
Warrant of arrest has been issued against this accused. No, you are absconding till now.
I have granted anticipatory bail by this Honorable High Court, page 13.
And when you
Recording is there, my lord, that I am not.
when you got anticipatory bail?
I have got anticipatory bail 21st May 2025. My lord, I have annexed that order, page 13. My lord, kindly come at page 13, my lord.
Did you appear before the court
Yes.
after
Yes, my lord.
taking bail, anticipatory bail, and made any fresh application for release?
Yes, my lord, 23/5/2025. That has been rejected.
But here, learned trial judge has held that you are absconding till then.
But my lord, that is a yeah. But my lord,
After getting bail, you need to
that is another
appear
part,
there.
that is another part. But
This is the main part, not another part.
my lord, because
You didn't appear before the learned trial court with all relevant documents.
my lord, I made an application through advocate that has been considered, that has been rejected.
Yes, that should be rejected.
Challenging that order
Because you did not appear before the court, and till then you were absconding.
That is another part. If my lord, I have been absconding, there should be an proclamation procedure. I have granted an anticipated. Kindly come page.
These are the procedural aspect, and learned trial judge will do.
Kindly come at page 13.
What is
Anticipated will granted by this Honorable High Court to me.
Then
My lord, that is the meaning.
did you get permission of granting anything, everything?
My lord, kindly come at page 13. My lord, there is a recording.
Yes,
by this Honorable High Court that that was not within my knowledge. Page 13, my lord, kindly come.
After getting bail, you should go there and make a fresh prayer.
My lord,
your prayer for return of vehicle rejected only on the ground that you are absconding.
That has not been reflected. My lord, kindly.
Yes, you go through with your
My lord, considering the petition dated 1/3/2000 filed on behalf of a petitioner accused regarding return of seized vehicle is rejected.
Read prior sentence.
Yes, both accused person, the Om Sadhuka and videos are produced virtually from the Hooghly District Correctional Home. My lord, after that, my lord, if my
Read prior sentence.
Yes.
It is admitted fact that. What is there?
Accused. It is admitted fact that warrant of arrest has been issued against the accused as this accused is absconder.
Then
if my lord desire, I can produce all the copy. Perhaps issued present.
You go and place there, na?
No, my lord, that is not fact, my lord, because my lord, I made a prayer for my lord, kindly, my lord, let me summarize that. It is not, it is another fact. I made a prayer for return of vehicle as per section 40.
Your prayer has been rejected.
Rejected on contest. That is not a ground, my lord. On contest, they have rejected.
Yes.
As per the judgment of the Supreme Court, my lord, in my lord, Biswajit, they have stated in Supreme, my lord, if that is not within my knowledge, that the contraband article, there is a business of contraband article.
How trial court? How trial court infer that these are not those were not in your knowledge? Only upon your statement, you come and say that that was not within your knowledge, and
they should consider the case diary. They have to consider the case diary. But order is there. High Court.
That's why I am
not my duty, my lord, to produce, because the case diary is there, because state was there at the time of granting anticipatory bail. And
you come after service.
Yes, my
You
lord.
come after service.
That I am seeking, my lord.
Learned advocate for the petitioner. Refer the impugned order dated 23rd May 2025, whereby his prayer for return of vehicle seized on 31st January 2025, which was involved in alleged which was Which was involved in alleged transportation one set packet of 100 gram ganja. State level one golden color mobile phone. 1 kg 400 ganja. One small 100 gram ganja. Only ganja were recovered.
Yes, my lord. One
From the
400.
possession of? From the possession of?
From the possession of 2%, my lord, that they who take a lease, my from.
What is your vehicle?
My lord, Mahindra pickup van.
Uh, what is the number of vehicle?
My lord, number of vehicle is.
Return of vehicle being Mahindra pickup van. Number?
Number is, my lord, registration number WV15E.
Yes.
26.
Yes.
92.
92. 1 kg 400 gram of ganja and 100 gram of ganja were recovered from the possession of Arun Sadhu Khan. Who was this person?
They are the driver and Khalasi, while
Driver of the vehicle.
Yes. And that person also granted bail
Sheikh
by the
Firoz, Khalasi of the vehicle. And the vehicle was recovered and seized since then. He prayed for release of the vehicle, but the same was rejected on the ground that petitioner Abhishek Rai, being owner of the vehicle, was absconding till 23rd May 2025. Later, petitioner was released on anticipatory bail passed in CRM bracket A 1365 of 2025.
Yes, 30, my lord, already.
On 21st May লিখেছো তো ডেট দিয়েছো on 21st May 2025. He is praying for an order for release of no. He is praying for what is your prayer?
My lord.
Praying for quashing of the impugned order dated 23rd May 2025. Let this matter admitted for hearing. He is directed to serve notice upon the estate OP estate through the office of the learned PP and file affidavit of service by 19th September 2025.
The date, my lord. While I can satisfy your lordship that
19th.
because I am within the ambit of judgment passed by the Honorable Supreme Court. Biswajit Dule.
Will consider. Today is the admission hearing. Your matter has been admitted. Don't show judgment of Biswajit Paul, Supreme Court. I am aware about that.
Yes, ma'am.
Number of times you have repeated same thing. Then what should we do?
Oh, my God.
Yes. Yes, yes.
So this is in this revisional application I have paid for transfer of criminal cases pending before the learned additional chief judicial.
Why you seek
Yalla.
transfer? Why you seek transfer? You are
In terms of section 407 CRPC. Now,
Yes,
Lordship,
sir.
kindly come by FIR, that is page 18 of my revisional application.
You are wife.
I'm the wife.
Why you are praying for transfer?
I'm coming to that. Lordship, kindly come the FIR first, the page 18 of my revisional application.
Yes.
Lordship, the initially case was started under section 498 and 406/34. Now, Lordship, kindly come the charge sheet already has been filed. Kindly come the second page of the charge sheet. Lordship, got it?
On your complaint.
Yes, my complaint. Charge sheet is also 498 and 406 against the members of the in-laws along with the husband. Lordship, kindly come the charge sheet, which is the certified copy. Second page. That is the first witness is the petitioner herself, who is the resident of Rampurhat.
Yes. Yes.
Second, Hiralal Sao, who is also 60 years old, resident of Rampurhat. Umesh Sao, Lordship, also resident of Rampurhat. Gopal Bormon is a resident of Bardhaman. Now, Lordship, Salauddin, this is also within the area beyond the Lordship, the Kolkata district, Lordship.
Yes.
Now, Lordship, most of the Lordship witnesses are residing in Rampurhat. This is my first
Yes.
ground.
Yes.
Now, second ground is, Lordship, kindly come my application under section 125, that is page 24 of my revisional application. Kindly come page 24 of the revisional application. My application under section 125 CRPC is pending before the learned additional chief judicial magistrate Rampurhat. Lordship, the husband is contesting this application and filed the affidavit of assets and also the show cause. Now, Lordship, kindly come page 36 onward. Up to 36(2), Lordship, 95, all the medical reports. Lordship, the de facto component, that is the wife, is in serious condition. Lordship, kindly see series of medical documents, that is this recent medical documents. So, Lordship, now the trial is continuing, Lordship, at
What is the stage of trial?
Lordship, trial is going on. Lordship, the
How many witnesses has been examined there?
Lordship, as on today, no witness, no Lordship. This charge sheeted witness
Since when trial is started?
Trial has not been served, but date summons has been served.
Going on means
the summon has been served, date has been fixed, but due to this medical problem, this PW1, that is the petitioner, is unable to attend. So, Lordship, I'm praying for a stay of limited stay and serve the copy of the revisional application.
Where is the copy of order sheets of trial court?
Trial court order sheet. This is the type copy. Kindly come, type copy, last 4-5 pages.
No order after 23.
So my instruction is
CSW1 not found. What is this? Your petitioner is not found. And same is mentioned at
yeah,
the relevant
the fact
column.
is, Lordship, the fact is, due to her illness, he could not.
Then
So, Lordship, for the time being, Lordship, let there be a stay, and Lordship, let the
stay of what?
stay of the proceeding pending before the court of London Court of Siala.
You didn't turn up. You didn't turn up.
No, Lordship, I have received summons. That is admitted fact. But
Yeah,
Lord,
warrant has been issued against you. Warrant has already been issued.
No warrant has been issued. As on today, no warrant.
Against your name, petitioner's name, not found is mentioned. Even in charge sheet. Relevant column of charge sheet,
Yes.
there is NF.
No.
Endorsement of NF. Here, what the copy you have provided here.
No, the landed advocate has received the charge sheet. Then how I received the file this?
No, come to the particulars of the witness to be examined, column number 14.
Yes, I am on column number 14.
Yes.
Yes.
And see
Sangita Sao.
The endorsement near the Sangita Sao.
Subsequently, I had received.
NF is there.
Lordship, I have annexed the charge sheet. That means, Lordship, entire copy, the concerned landed
Charge
advocate
sheet
has
was
received.
filed on 30th June 2013.
13th, charge sheet I have received, everything.
And now we are in 25.
Yes. Subsequently, Lordship,
One June has been left. And still we are praying for transfer.
No, subsequently, kindly
for
come.
further 12 years.
Now, kindly come. I am ready to, Lordship, give evidence. But, Lordship, kindly come, page 36. Page 36.
And praying for stay of the proceeding.
Proceeding means,
As if you are appearing
concluded.
every day.
Expunging the witness, expunging the witness of PW1
It is better to suggest your client to come and adduce his evidence. That will serve her purpose.
But Lordship, see, according to her, Lordship, she is unable. She is unable
She
to
could
move.
not be cured when this matter could be transferred to Rampur Hart. Even near at home, if we can construct a courtroom just adjacent to her home.
I am not praying. Lordship, because
even then she could not go there to adduce her evidence.
Lordship, kindly, Lordship, consider this aspect. Lordship, kindly come this medical report. Consider this medical report.
It is.
I have also once
if
to
she is
conclude this proceeding.
not able to appear due to such medical condition, then she will never appear before anywhere.
So she will die, Lordship.
Be it dum or whatever
No,
it may be.
We have to see, Lordship, that this is a criminal trial. Lordship, if it is transferred, whether the prosecution case will be happening.
After delay of 12 years.
No, Lordship, the witnesses are available. All witnesses available at Rampura.
So
that will be more justified.
Let them come and deduce their evidence.
So that's why this petitioner PW1 is unable to come. That is the medical problem.
Make prayer for recording of her evidence on commission.
The Lordship, kindly direct that.
You make prayer there, na? For that revision application is not necessary. Revision is not necessary, sir.
Lordship, my prayer
you make prayer before learned trial court. If trial court will not entertain your petition or pass any order against your interest, then you can approach this court. This is
Lordship, kindly, this is not the petitioner's case. Lordship, kindly consider the CS all witnesses, charge-sheeted witnesses.
Yes.
That most of the witnesses are residing in Rampura. That's why, Lordship, kindly consider how this order of transfer from Sialda to Rampura will prejudice these opposite parties.
In that,
We will have
that
the
event,
prosecution case. Kindly consider this
in that
aspect.
event, all the accused are resident of Danda, and they will face inconvenience.
So kindly
In-laws are
direct them day-to-day basis.
old aged in-laws are there.
Lordship, only one thing. Let them direct them to day-to-day conclude this proceeding before Rampura within a certain 1 week time. Day-to-day. It will be easier.
Most easier is to give instruction to your client to come and adduce their evidence. Leave petitioners aside.
Lordship, I have. But Lordship, this is the same thing I have to repeat, Lordship.
No.
This is the medical.
I can understand.
Medical
You have some
problems
limitation.
and Lordship, the persons who are Lordship supposed to give evidence all are residing within this locality. And that's why Lordship, kindly, this is the purpose of section 407. Lordship, kindly consider section
407
7 CRPC.
Yes.
And especially section 407(3).
Yes, I am there. Every application for an order shall be made by motion which shall accept when the applicant is the Advocate General of the state, be supported with. Subsection 3 is nothing. That a fair and impartial inquiry or trial cannot be had you come after the service of notice. Learned advocate for the petitioner is present. He prays for transfer of criminal trial arising out of Chitpur Police Station case number 94 of 2012, dated 5th May 2012. GR case number 1308 of 2012. Pending before the learned Judicial Magistrate First Court, First Class, Judicial Magistrate Second Court, Sialda, South 24 Parganas, to the learned Additional Chief Judicial Magistrate Rampurhat, Birbhum, as the petitioner is unable to adduce her evidence due to severe illness. Other CSW charge-sheeted witnesses are resident of the Rampurhat, and they are only resident of the Rampurhat. Others are 29, 40, 43, 24-year-old. They can come.
Yes, two persons
are the resident of Rampurhat. It would be convenient for them to adduce their evidence at any court, before any court at Rampurhat, which will serve the object of fair and impartial trial let this revisional application be admitted for hearing. Learned advocate for the petitioner is directed to serve notice on OP number 1 estate through the office of learned PP and OP number 2 to 6 at their postal address. Through a speed post with AD and file affidavit of service by 26th September. 2 week time, I think, would be sufficient for you. And 26th. This matter will appear on 26th. Yes.
Lordship, I will liberty to file a supplementary affidavit annexing the subsequent orders.
Yeah. Liberty is granted to file subsequent orders of learned trial court.
Yes.
By the adjourned date. Yes, yes. Yes. But
item number 12. May I kindly come? I am praying for quashing of an FIR. May I kindly come to the opposite party?
Party jo to.
May I kindly come to page 11. FIR. And I am Shubroto Kanrar.
Yes.
Number 2.
Subato Kanrar.
Kanrar. Now, we'll come to the previous page.
What are the corresponding section?
We'll come to the previous page once. 131. Well, sections 131, 127. We'll kindly see section 131, 127. Well, section 131 is one minute. Come back.
Your section is
115
bracket 2
yes
and 351 bracket 2 of BNS.
That is what they have alleged. Now, we kindly come to the previous page.
Yes.
This is summons to the accused persons.
Summons to the accused.
The court has taken cognizance of 131 and 127.
Yes.
131 relates to, it's corresponding to 352, that is assault, criminal force. Nowhere made out in the FIR. Use of criminal force is not made out. Secondly, my lord, second one is wrongful confinement. That is also not being made out from the FIR. These are the two sections of which cognizance has been taken and summons has been issued.
सागर दिघे तनार अंतर्गत आता तृतीय स्वाक्षर
Is 127?
है तो है निकाल के यहाँ रखिएगा तब ना बार बार फोन करे সত্যি আসামিদের কোনো খোঁজ পাওয়া যায়নি।
And now, my lord, okay, my lord, we'll go through this one.
Yes, yes, yes.
Now, my lord, we'll kindly come to the next page, page 30. I am one of the, my lord, employees of this tour and travels. I was, my lord, will kindly see how I have been deemed by this manager. Even I had to lodge an FIR. Manager has fled away. I am only an employee. My money has also not been given. I'm a cook rather. That next question.
এফআইআর করতে স্টার্ট হয়েছে, কমপ্লেন দিয়েছো,
টাকা দেয়নি কি করবো?
কমপ্লেন দিয়েছো, এফআইআর স্টার্ট হয়নি, তুমি বলে এফআইআর।
Yeah, this complaint has been filed by you.
Yes, ma'am.
Subrata Kumar.
Baguyati police station. Also Luberia police station, that I was appointed by him. In the midway, he also left me. He did not make payment to me. I had been cooking. I had cooked. I have made.
OC Baguyati.
Well, yes. And the next.
And under is the OC Rajapur.
Luberia.
Why have you filed two
complaints? Two different places, man. Sent it.
Yeah.
Well, that he has the main accused has not paid me my money. I'm an employee.
And this application was filed by Kaushik Lala.
Yes, man. They have been these people have also been cheated by this particular owner. What is his name? Shoti Mukherjee. They have also been cheated. I have also been cheated.
Then
I am praying for quashing of my case. Let Shondip Mukherjee face his consequences. I have got no problems with it.
And the case lodged by you should continue.
My lord, yes. My lord,
This is your prayer.
I have been duped, my lord. I have been sent to Kashmir to cook, and in the meantime, he left. I
take down. Learned advocate for the petition. All of you for the petition?
No, my lord, petition has been served upon the opposite party number 2. I am for the opposite party number 2. I am appearing on behalf of the opposite party number 2.
In this case?
Yeah. I am the complaint in the court below. My lord, the complaint. Kaushik Lala.
So he is praying for quashing of your case.
Only against one.
My lord, kindly see the next date for recording of deposition. It's a CR case. No initial deposition has not been taken place. My lord, the learned court, maybe the peon or somebody, what they have done, they did a wrong thing. They without deposit,
before deposition.
Yeah, before deposition,
summons couldn't be issued, my lord.
Yes, my lord. In that regard, my lord, our High Court has recently passed a judgment. My lord, kindly, I am handing it over.
Oh, you may refer judgment.
My lord, kindly.
Today is for admission. Today is fixed only for the admission. It appears for under the heading of admission hearing. So let this matter first appear. And since you are in attendance, then notice is not required to.
No, my lord. My lord, kindly fix on next day, any day in next week.
My lord.
Learned
may I pray for a statement?
Advocate for the petitioner raised for quashing of CR case number 335 of 335 dated 23 July 2025.
The cause title may be amended, man.
Under section 131
দেখো কি করেছো cause title
oblique 127 3 of BNS pending before learned ACJM at Jangipur, Murshidabad. OP number 2, Kaushik Lala, is represented by learned advocate. You furnish your name, please. Did you file your wakalatnama?
Yes, my lord. My junior has filed.
Let this revisional application be admitted for hearing Learned advocate for the petitioner is directed to serve notice to OP1 estate through the office of learned PP and file affidavit of service on the adjourned date. He is also directed to furnish a copy of revisional application to learned advocate for the OP number 2. Let this matter appear on 19th.
My lord, for the next day is
19th.
19th September, my lord.
Yes.
Leave lord.
I did leave to correct the constitutional manner. One has been wrongfully treated in the court.
Who?
CR case number, it will be 335. Wrongly 335, one has been.
Yeah, give me the case. Three, 335 is here. No, one is not here.
Well,
Only 335.
in our copy, this is 335.
No. You may verify it. Yes. ठीक है, yes, next.
Item number 30. My lord, I am for the petition. My lord, will kindly come to page 24. My lord, we are the sister in.
All are same case?
Yes, my lord. My lord, two sister-in-laws, and the third one is for the husband. That I take. First one, the husband.
And all are for the quashing?
Yes, my lord. But this is an official translation of the first information report. But we'll see whether against the sister-in-law anything is divulged.
This is the matrimonial.
The only is that my two sister-in-laws, such and such, are also involved. This is the only allegation, only line.
Involved in?
Nothing. Involved in torturing. Yes, they are staying there. Everybody is staying in the same house.
These are the common allegation.
Yeah,
Nothing
this
new.
is the allegation. They are involved. And 498 a proceeding against two sister-in-laws going on.
Take down. Learned advocate for the petitioner is present and submits that petitioner is husband.
Husband petitioner one. Yes,
only one petition is here.
No, there are three.
So why you file three separate?
File, my lord.
No. This is not true.
My lord,
you have to file together, na?
My lord,
arising out of self-same incident.
No, my lord, I'll tell you. Regarding the husband, we felt that husband would be treated differently from the other two sister-in-laws in a marriage.
No.
Not always, my lord. That is true.
No.
Yes, my lord.
They are defective.
No, my lord. I can file three different applications as well, my lord, if I want to.
No. Not required. Unnecessary. You are increasing the number of.
My lord, will tag all the three applications, my lord, and pass a single order. That your lordship can do.
Petitioner is the husband. Praise for quashing of ACGR case number 7438 of 2024 pending before the ACJM Alipur South 24 Pagnas arising out of Regent Park Police Station case number 290 of 2024 dated 18th December 2024 on the ground stated therein. Prima facie I find sufficient material to register to admit this revisional application for hearing. Accordingly, this revisional application is admitted. Learned advocate for the petitioner directed to serve notice on OP number 1 state through the office of learned PP and on OP number 2 on her postal address through a speed post with AD and file affidavit of service. How much time you need?
7 days.
By 19th September. Let this matter appear on 19th September
Stay till then.
for filing of affidavit of service. He further submit that CRR 3251 of 2025 and CRR 3252 of 2025 वो तीनों में आलदा कर दो अच्छा इन दोनों में सिमिलर ही हो
stay, my lord.
Stay of what?
Proceedings, my lord.
Which proceeding?
Of the 498A proceedings, which is pending before the trial court.
Investigation is going on.
No, my lord. Charge sheet has been submitted. My lord, the case diary also may be required.
The prayer for a stay of the proceeding.
Page 25, my lord, is the charge sheet.
Of the ACGR, ACGR case number 7438 of 2024, pending before ACJM Alipur, South 24 Pagnas, is a stay till second week of the second week after the vacation or until further order, whichever is that. बाकी 14-15 में भी सिमिलर ऑर्डर हो जाएगा. Name of party shall be changed.
Well, it's in the second half, your lordship will not sit, my lord.
Just a minute, sir. Wait. Yes.
In second half, my lord, your lordship.
I will not sit.
So, my lord, then my lord.
No, no.
In that event.
Please wait.
Then.
Yes, please wait. I will call. Yes. None appears. It's your first day. Yes.
Item number 15, my lord.
What? You are?
I'm for CRR 3253.
Yes, this is item number 16. Yes.
Oh, I'm sorry, my lord. No, item number 16, my lord, kindly paying a short pass over, my lord.
Why?
So the advocate on record will do the matter, my lord, kindly.
No password.
And then kindly give me not.
You start. Not today, no. No such order. You start. What is this matter?
This is a quashing of proceeding.
Learned advocate for the petitioner. Praise for quashing of the proceeding.
Well, kindly hear me out.
GR case number. Proceeding of GR case number 2891 of 2021, arising out of Tangra Police Station case number 313 of 2021, dated Dico dated 27th/11/2021, initiated under section 498A, 313, 323, 406, 506, 34 of IPC and section 3/4 of Dowry Prohibition Act, pending before Judicial Magistrate First Court at Sialda, South 24 Pragnas. On the ground stated therein. Prima facie, I find sufficient material.
My lord, may I submit two things, my lord?
What? Yes, you may submit.
My lord, kindly go through the FIR. My lord, kindly see the
Should I not admit?
Yes, your lordship.
Do you want to?
I want a stay of the proceeding, my lord.
Okay.
My lord, kindly see two things, my lord, kindly.
Yes, yes.
My lord, the opposite party number 2 voluntarily left the house, my lord. Thereafter, my lord,
Yes.
kindly see page
These are
27.
the common story.
My lord, kindly see page 27, my lord. I have lodged a GDE dated 10th of July 2021, my lord. Thereafter, husband filed a mat suit. Page 32, my lord. Kindly see, my lord. Thereafter, receiving the summons, this FIR was lodged. And my lord, these petitioners are not the husband.
You
and the
are
mother-in-law.
your father-in-law.
I am father-in-law, sister-in-law, and the husband of the sister-in-law, my lord.
Then why you lodged a complaint?
Father-in-law and
who is Manju Devi?
My lord, Manju Devi is the mother-in-law, my lord. I am not for the mother-in-law. The petitioners are the father-in-law and two sister-in-law, my lord. Allegations are against the husband and the mother-in-law, my lord. Kindly see the FIR at page 44, my lord. Against us, there are no allegations, my lord.
Then should I pass pass order?
Well, kindly stay the proceeding against us, my lord, my lord.
For that, first of all, this revisional application is required to be admitted. Thereafter, we'll hear you on merit. Na? Why are you wasting time?
No, I am not wasting time.
Yes. I find sufficient. Let this revisional application be admitted for hearing. Learned advocate for the petitioner is directed to serve notice on OP number 1, state through the office of the learned PP, and OP number 2, at her residential postal address through a speed post with AD, and file affidavit of service by the adjourned date. Yes. Where is your prayer for stay?
My lord,
stay of all proceeding imputed criminal.
Page 20.
Learned advocate for the petitioner prays for an order
Charge sheet at page 52.
Order for staying of all proceeding of impugned GR case number 861 of 2021 till the disposal of the instant application. Let the proceeding pending before. Yes. Do you want to submit in?
Kindly says the parents had lodged the GD for their resulted petition.
Oh, well,
Thereafter,
good.
one thing the two ladies now are married sisters-in-law residing elsewhere as per the Supreme Court judgment of Calcutta.
We'll hear you on merit at the stage of.
At stage because the married sisters-in-law have been implicated. Who decide? Admittedly, do not decide.
Yeah. These are the general elections. Yes.
General elections.
Let the state till the second week of the second week after the puja vacation or until further order, whichever is earlier. Let this matter appear on 19th for filing of affidavit of service by the petitioner. Yes. Yes, yes.
Item number 17.
Item 17, I appear for the petitioner. I have prayed for quashing of the charge sheet. That I think I am a purchaser, I am the owner of a land. The opposite party number 2 had lodged and his associates wanted to encroach into the land. I had purchased the land, the registered sale deed is annexed. I had recorded my name in the mutation. The record of rights have recorded my name. Thereafter, since they wanted to encroach into my land, I had lodged a GD on 5th of June 2024. I had lodged a complaint that was registered as a GD. The next day, it was registered as an FIR. Investigation was done, charge sheet was submitted, wherein 307 was added against the opposite, the accused persons. On 6th, the next day thereafter, one of a lady goes to the police station, same police station, and lodges an FIR alleging 354 and other offense. And I prayed for quashing of that the FIR that was lodged on 6th of June, being FIR number 117. There was earlier, since they intended to encroach upon my land, I had preferred an application under 144 before the learned magistrate. The learned magistrate initially passed an order recording upon the police report that the other persons were trying to encroach into my land. The next day, suddenly the magistrate records that I am trying to encroach into the land of some other person. That order of the magistrate was stayed by this honorable court, which the order I have annexed is at page 54.
Yes.
And I was praying for quashing of the proceeding that was lodged on 6th of praying and quashing of the charge sheet which was lodged against me.
Then what is your prayer here?
The quashing of the charge sheet was lodged.
Why, on the ground of?
Well, this is a count. The second, the FIR that was lodged against me was basically a counterblast to the FIR that I had lodged. Since they could not, since they were enjoying that land without any hindrance earlier, once I purchased, I had demarcated and taken possession of the land. I wanted to build an hospital there. Now,
Yes.
certain persons of the locality who were enjoying that land prior to that,
Yes.
without any hindrance, they were enjoying that. They wanted to grab that land so that they can continue.
Very well. Take down. Learned advocate for the petitioner is present and submits that that the proceeding of GR case number 1550 of 2024 arising out of Salboni Police Station FIR number 117 of 2024 dated 6th June 2024 under section 325, 321, 341, 354 and 34 of IPC pending before 6th Judicial Magistrate Midnapur Paschim Midnapur on the ground that the entire proceeding was initiated in the counter blast of the FIR lodged by the petitioner earlier. Prima facie sufficient material is available on the record to admit this revisional application. Accordingly, the revisional application is admitted. Learned advocate for the petitioner is directed to serve notice on OP number 1 estate through the office of learned PP and OP number 2 wife on our postal address through the speed post with AD and file affidavit of service by the adjourned date. Let this matter appear on 19th September 2025 for filing of affidavit of service by learned advocate for the petitioner.
Well, I was praying for stay of the proceedings.
Where is your prayer?
Well, prayer is at page.
If further submits for an order
At page 11.
to a stay of all further proceeding of GR 1550 of 2024 pending before learned trial judge till the disposal of this revisional application, let the proceeding of the impugned case be Mr. Rasul, will continue till 2. Please. Will continue till 2. Please cooperate me. So many matters are pending and I have to admit them. That's why I am running short of time. Accordingly, key लिख लें. We state till the 14th November 2025 or further order, whichever is earlier. Yes.
I'm grateful.
Thank you. Yes. Yes, call the list. 18. Item number 18.
18 and 19. One the 125 and one the domestic violence, both maintenance, filed by the wife.
Your wife.
I the husband.
You are
the 125 and domestic violence filed in the year 2008.
So take care of your wife.
Why
are you annoying your wife?
Wife is a teacher. Wife also secondary teacher. I being a headmaster. But both the matters.
That's why you are headmaster and your wife is teacher.
Teacher. One matter pending before the ACGM and one matter pending before the judicial magistrate. In domestic violence, pending. The second judicial magistrate at Alipur. But my prayer, my lord, that domestic violence case will be placed before the ACGM and also, my lord, disposed in as early as possible. But 2018 125 matter pending, my lord, both all the states, my lord,
why those matters are pending? If you are so interested and willing to do,
wife, my lord, praying adjournment, Several times, my lord, paying adjournment, he filed the case.
Did you mention these facts before the trial court?
But my lord, that one, my lord, matter, both the matters is a maintenance, relating to maintenance. One matter pending before the ACGM, and my lord, one matter, my lord, the Judicial Magistrate Court number 2.
What is your prayer? What you want here?
Prayer, my lord, the second, the domestic violence we place ACGM, and my lord, both the case, my lord, as early as possible.
Oh, chaliye.
18 and 19, my lord.
Where is your prayer? Item number 18. आगे ना. Expeditious disposal. The petitioner submits for a direction to the learned Judicial Magistrate Second Court at Alipur, 24 Parganas South, for expeditious disposal of complaint case number 4796 of 2018, TR case number 895 of 2018, filed under section 12 of the Protection of Women from Domestic Violence Act 2005, by OP number 2, wife, against the petitioner, considering the innocuous nature of prayer, petitioner is exempted from the service of notice to the OP. Learned trial court is directed to take necessary endeavor for expeditious disposal, hearing and disposal of the above referred case without granting any unnecessary adjournment, accordingly, this revisional application is
reasonable time, 6 months or 8 months, or
No.
2018 Malad case.
no
But
time frame can be
But
without
2018
granting.
case, 2018 case, Malad, the
Other things are left upon you, sir.
7 years already, 8 years already, Malad. I being the husband, Malad, the
Yes, sir. You go and mention there, and I have given him direction. No such time-bound direction could be.
And also, Malad,
given.
that
Such practice is highly deprecated by the Honorable Supreme Court. So, such a direction,
Malad, that both the matter regarding maintenance, section 12.
it may be you.
But Malad, 125, but that matter be placed before the ACGM. Well, next matter, Malad, pending before the ACGM.
Yeah, similar direction, ACGM ka छोड़ दे.
Well, that matter may be placed before the ACGM, but 12, but both maintenance.
Yes.
But 125 pending before
That
the
order cannot be granted.
Otherwise, Malad, the same
Both court should be directed to disposal your matter as early as possible.
But they are both maintenance, my lord. That
As per their diary.
yes, my lord.
What is
But
the-
I have no. But my lord, the SCJM, if my lord SCJM, that matter is my lord, the witness is going on 125 matter. My lord, that court, my lord, maybe section 12, both maintenance. But that is no difference, my lord.
No such a prayer you have made.
But why the 156, my lord? Can you see? Next matter, my lord.
Yes. Next matter. Yes. What is your prayer? Yes, yes. 19th, yes.
Well, this is a 125 matter.
यहाँ के 10 मिनट लेट होगा 10 मिनट लेट होगा
Well, this is a application 125, not wife filed in the year 2018.
as early as possible without giving unnecessary adjournment. This is your prayer. Same order. এইসব দেখে ইয়ে করে দেবে কোর্টকে নাম চেঞ্জ হয়ে যাবে আর কেস নাম্বার চেঞ্জ হয়ে যাবে বলে দেবো না করে নেবে এই কোর্টের নাম হয়ে যাবে বাদ বাকি প্রেয়ার সব একই আছে yes হ্যাঁ yes same order expeditious disposal yes
Item number 20. Your Lordship, I am for the petitioner.
Yes.
Your Lordship, I have filed this matter for the petitioner for the appropriate order, which is the impugned order passed by the learned 3rd Additional District Judge at Barakpur on the 20th of June 2025, wherein he has doubled the amount of maintenance, Your Lordship, from 9,000 to 18,000, Your Lordship.
yes what is your profession
Your Lordship, first, Your Lordship, I would like to state some of the facts. Your Lordship, the petitioner and the opposite party number 2, they were married on the 27th of January 2023. Thereafter, Your Lordship, after 2 days, she went to her matrimonial abode for Ashtamangala rituals. Your Lordship, thereafter, she did not return till the 22nd of March 2023. Your Lordship, then Your Lordship, she came back on the 23rd of March 2023 to celebrate her birthday, Your Lordship. I have annexed the pictures of the birthday celebrations, Your Lordship.
yes yes yes
P1, Your Lordship, page number 18, Your Lordship. Thereafter, Your Lordship, on the next day, that means, Your Lordship, on the 23rd of March 2023, at the morning of 8:25, the petitioner had a flight because he had to go to work to Bangalore. So, Your Lordship, he left. Thereafter, the opposite party number 2, Your Lordship, was staying at the matrimonial abode. On the 24th, Your Lordship, she said to the mother-in-law that I don't want to stay with your son. I want a divorce. I want alimony. I want to leave the house. And thereafter, she left the abode, Your Lordship. Thereafter, Your Lordship, the petitioner came back on the April 10th, 2023, and he persisted a lot of times. He said the opposite party number 2 returned back to the abode, but she did not return. And thereafter, Your Lordship, she filed these proceedings. First, Your Lordship, she has filed a FIR under 498A, 322, 406, 34, and 3 and 4 of the Dowry Prohibition Act. Thereafter, Your Lordship, she filed a maintenance case 597 of 2023. Thereafter, Your Lordship, where the order was passed of 9,000 per month. Your Lordship, the petitioner paid 2 or 3 installments, Your Lordship, of this 9,000 per month. Your Lordship, thereafter, she filed a revision application, wherein, Your Lordship, the learned Additional District Judge, 3rd Court of Barakpur, he doubled the amount of maintenance, Your Lordship.
where is the interim
Impugned
order
order is, Your Lordship, in page number.
what is your profession
Your Lordship, that at present, Your Lordship, the petitioner is jobless, Your Lordship. The petitioner is unable to pay your lordship 18,000 per month.
Yes.
Lordship, 25th of September is the next date fixed, your lordship, before the learned trial court, and the learned trial court has given a direction to pay 60,000, your lordship.
Did you file your affidavit of assets and liabilities?
Yeah, your lordship.
So let the trial court decide this matter.
Your lordship, the opposite party number 2, the wife, your lordship, she has suppressed a number of facts, your lordship.
What is her profession?
Your lordship, she is a bachelor in computer education. She has 2 beauty parlors, your lordship. I have annexed one of the, your lordship, deeds of the beauty parlor.
That's why she didn't want to stay with you.
No, your
You
lordship.
are jobless. You did nothing, and she has to. She is running 2 beauty parlors.
Your lordship, that is not the case, your lordship. The case
That is the case.
suppressed a lot of facts, your lordship, before the learned trial court. She has suppressed a lot of facts, your lordship. She has not stated, even in her assets and liabilities, your lordship, she has not given regarding these business, your lordship, or
Yes.
earnings, your lordship.
Then why are you praying for Quashing?
Sir, your lordship, I am praying for setting aside this impugn order, at least to reduce the amount, your lordship.
No.
Your lordship, the
Your
petition-
prayer is you have made prayer under section 482 of the CRPC.
Yes, your lord, along with your lordship, 401 of CRPC.
Yes.
Along with 401, your lordship. And in my prayer also, your lordship, I have stated to reduce the amount of maintenance, your lordship, because the petitioner cannot pay, your lordship, 18,000 per month, your lordship. It is very difficult for him.
Take down. Learned learned advocate for the petitioner submits that petitioner is husband. Their marriage
Your lordship,
petitioner is husband,
2020.
and his marriage with OP number 2 was solemnized on 27th January 2023. Thereafter, OP left for her matrimonial abode on 22nd March 2023, and she on the next day, and she stayed there till 22nd March 2023, when she returned at her matrimonial home to celebrate birthday. Thereafter, petitioner left to his place of work at Bangalore on the next morning by flight. In the meantime, OP resided at her matrimonial home, where she disclosed to her mother-in-law that she didn't want to continue, want to stay with the petitioner, and initiated several proceedings against the petitioner. She lodged a complaint or written complaint. What is there?
Your lordship, at first she filed a case of 156 clause 3 CRPC. Thereafter, FIR was lodged.
To complaint.
This case was filed.
To complaint under section 156(3) of CRPC, upon which the FIR was lodged, and instant impugned proceeding was initiated against the petitioner. In other proceeding under section 125 of CRPC, learned magistrate, which court?
Your lordship, fifth court of Barrackpur, fifth judicial magistrate of
Learned judicial magistrate, 5th court at
Barrackpur.
Barrackpur, passed an interim passed an order for interim order maintenance of 9,000 rupees, which was enhanced to 18,000 by
Learned Third Court, Additional District Judge at Barakpur.
learned additional district judge third court at Barakpur in criminal revision 444 of 2024, which is the order impugned in this revisional application. Prima facie arguable facts are available therein which needs to be determined by hearing. Accordingly, this revisional application is admitted. Learned advocate for the petitioner is directed to serve notice on OP number 1 estate through the office of the learned PP, and OP number 2 wife at her postal address through a speed post with AD and file affidavit of service by the adjourned date. Learned advocate for the petitioner further submits for an order to stay which proceeding?
Your Lordship, MEX misexecution case number 109
Stay
of 2024.
of misexecution 109 of 2024 and maintenance case number 597 of 2023 till the disposal of this revisional application. Let the proceedings be stayed till 14th November 2025 or further order, whichever is earlier. Let this matter appear on 19th September for the filing of affidavit of service by the learned advocate for the petitioner. Yes. Thank you. 21.
Appear for the petitioner. It is an application for expeditious disposal. Crux and kernel of my complaint, my lord.
Take down. Yes.
Crux and kernel of my complaint is that, my lord, if I may.
Where your কালকে তো expeditious disposal কে করেছিলে তো কালকে expeditious disposal কে করেছিল তো expeditious disposal of complaint case number હતો since when your matter is pending there?
The matter is 2021.
What is the stage of trial?
The stage, my lord, on the last occasion, police report was called for afresh.
Eh?
The police report was called for afresh.
Police report
Was called for. A fresh police report was called for. and the investigating officer was
whether trial is started or not.
My rank for the petition. This is a complaint case that has been filed, my lord. After the filing of the complaint case, the police report was called for. Okay, the police report was called for. Subsequently, it was disputed, and once again, fresh police report was called for. Till now, the report is not submitted. My lord, the IO was called for personally.
So whom should I direct? Whom should I direct?
And the learned trial court. It is
for what?
pending
For what?
for expeditious hearing, my lord. Just
Hearing is not yet started.
No, my lord, to conduct the trial as expeditiously as possible.
Trial started.
My lord,
What is the state of trial? How many witnesses examined here?
My lord, if the matter in a complaint case, the matter is pending from 2021.
Yes.
If my lord comes to
The case is adjourned to the for hearing in presence of PSI.
My lord. Second last page, my lord.
Yes. Whether trial has started. Record in complaint. What is the submission? For ER of WA.
Yes, my lord. And that has been pending since long, and this is going on. The police has not filed any report.
Did you make prayer before the trial court?
Yes, my lord. Everything is there. It is. If
What
my
is
lord,
the outcome of your prayer?
Nothing, my lord. If my lord comes to page number.
At this stage, no direction can be passed to.
If my lord kindly sees order dated
disposal
3rd
for
August.
the early trial.
My lord.
But trial has not yet started.
If my lord kindly appreciates one thing.
No, misconceived.
My lord, just give me 5 minutes to satisfy my lord.
No satisfaction.
My lord,
This is the last order what you filed, dated 4th April 2025.
Yes, my lord, and the filing is done in the year 2021. My lord, on 3rd August 2023, call for a report. If my lord, the reports are not been given, the trial cannot be
Learned
reached
advocate
also.
for the petitioner prays for expeditious disposal of the complaint case number 4929 of 2021.
Yes, my lord, it's pending since 2021.
Pending before the learned judicial magistrate 7th court, Paschim Bardhaman at Asansol.
At least without any adjournment, my lord, lots of adjournment has been taken.
You may move there, na?
My lord, that is also done, my lord. At least some protection.
It appears from the order dated 2nd April 2025 that what happened on 13th August?
My 13th August 2025. My lord, the police was called for, none appeared. That date also. It is in the e-courts, my lord. This has been filed after that. It is still just dates and dates are going on, my lord. Let that be done as expeditiously. I will also cooperate. No adjournment is needed.
Ki likh le? That this case was adjourned till 13th August 2025 for hearing in presence of PSI. Who is PSI?
Shubhendu Pal, Sub Inspector. Order number 27.
Hearing of the report in presence of PSI Sri Sendhu Pati.
My lord, this stage is going on for the last 3 to 4 dates only.
Investigation is still has not yet completed. Learned not yet completed. Question of initiation of trial does not arise. As such, no order for expeditious trial could be passed. However, learned Judicial Magistrate 7th Court Asansol is directed to conclude the hearing as early as possible without granting unnecessary adjournment. Accordingly, this revisional application is disposed of.
Much obliged.
Yes. One more matter can be taken. We'll hear you as a last matter of the day.
Madam, for the opposite party.
You are? And you are?
Opposite party wife.
Oh, both appears. So admission hearing.
Admission stage. My lord, I have not been served with copy because it is for the first time.
I'm giving direction.
Well, only one thing. If your lordship is dealing with the impugned order dated 4/3/25.
Delay?
No. 4/3/25.
Lordship, the impugned order is of 10th June 2025,
Then-
where distress warrant was issued against me. Lordship, without application of the judicial mind and without any sort of
Its execution is pending.
Yes, 2,52,000 is
Why don't you
till
pay?
date. Not a single amount has been paid till day. Warrant is
Why,
pending.
what problem you are
Kindly
facing?
see the audacity, my lord. The person.
Lordship, I am a worker.
What is your profession?
Lordship, I am a day worker who gets only for the day when I work.
Manager of a hotel. Manager of a hotel. My lord, kindly see these pictures, my lord. Police are not getting even locality. I am taking photos, giving to the police. But police is saying, how can I catch? I don't know where he is. What more a lady can do, my lord?
My affidavit of assessment liability is on page number 32, where it is
I am maintaining a minor child, my lord, that to a girl. A minor baby is with me and maintenance is not allotted to me. The baby has been given maintenance and residence order has been given. Kindly see. The maintenance order was granted only to the baby, 13,000 to the child and 5,000 to residence order. Obviously,
You are dragging this matter. It is better to start payment.
My senior is out of.
No appeal is filed with respect to the impugned order. Only showing warrant and urgency, my lord. This can't be done, my lord. There is section 29 bar, your lordship knows.
Mr. Mohit Mukherjee.
No, he cannot change the fact of this case. No?
Lordship, then let him argue on the merits.
My merit is that I am not getting maintenance.
Will hear your merit on the date of hearing.
My lord.
Today is the admission hearing. Date for the admission of this application. No, this is not regular court.
But I don't think, my lord, why without challenging the main order, which is which has to be assailed. Section 29 appeal before the learned appellate court. Without challenging that order, my lord, how can execution directly before this honorable court? By showing the urgency. The urgency lady is suffering.
Very well. On the prayer of learned advocate for the petitioner, let this matter appear on 19th.
In the meantime, copy be served, my lord.
Petitioner is directed to serve copy of this revisional application to learned advocate for the OP2.
My lord,
OP2.
I have no copy, my lord. Let me see.
No, only one OP is there.
Only one, then
OP. OP wife who appears yeah. No, for that direction is not required. You may hand over.
22nd.
No, 19th.
Kindly, Lordship.
No.
My lord is fixing on. My lord is fixing on.
Yes, 19th.
19th. But only one thing, my lord, only one thing. Pendency of this application will not create any disturbance.
I'm not granting any direction. Only adjourn.
My lord, deeply obliged.
No further.
Deeply obliged.
Mr. Mukherjee will be here on 22nd.
No, madam, I could not accommodate in that manner. You should know this is not regular court.
Deeply.
Consider my inconvenience also, na? No, pass over matter. We'll hear you. Yes. Please.
Item number 3, PRAN number 5 is my application for extension. Your Lordship, page 14 is the order.
What step you have taken in the meantime? Only for extension of order. Every time
Your Lordship, kindly fix it.
prayer for adjournment was made.
Kindly fix any date. We are ready. We will argue the matter on merit, and Your Lordship.
This matter appeared on 8th August, but on the prayer of learned advocate for the.
Your Lordship, I am for the opposite party. Your Lordship may kindly fixes a date for hearing, Your Lordship.
Your Lordship, the matter is pending for a long time. Your Lordship, kindly fixes the day
If you
for
have
final
urgency,
hearing. Your
then
Lordship.
you may make prayer to place this matter before regular bench. This is not regular bench.
Your Lordship, I understand the
So,
predicament.
Your Lordship,
one day adjournment will make delay of 1 week. So, if you are in urgency, then you may make prayer for placing this matter before
Your Lordship,
regular bench.
Your Lordship, I understand, but I am not seeking for any adjournment. Your Lordship, the matter may be heard out on merits, Your Lordship, if Your Lordship so desires.
Yes.
The difficulty is, Your Lordship, the matter has been pending for a long time, Your Lordship.
Affidavit
And
of
every time-
service of CRAN 5 filed by learned advocate for the petitioner is taken on the CRAN 5 is an application for extension of interim order dated 20th December 2024 and extended in the meantime.
last extension was granted on 11th of July 2025, which is at page 14, Your Lordship. Up to 22nd of August, it is filed within time.
The application is filed within time. Do you have any objection?
Your Lordship, kindly fixes any date before vacation, Your Lordship. Not with
let
this, Your
the
Lordship, but a very
interim
short.
order granted earlier is extended till 21st November or further order, whichever is earlier. Parties are directed to come prepare on the adjourned date. Let this matter appear in list on 26th September.
26 September.
26th.
In this matter, I am since long my appearing my lord. Justice Sompar has the branch of Sompar. But my name may be regularized. Then where
You give your appearance, na? Then your name.
regularize my name.
We had served the, your lordship, when the.
Your name is appear
Yes.
in order sheet.
Yes, in order sheet. In order sheet.
Then
Your lordship on
there is
20th of December.
to learned PP.
No, the competent authority, your lordship, kindly done competent
Estate is represented by, since estate is represented by Mr.
Vidyut Kumar Roy.
Vidyut Kumar Roy
Since 20th December 2024.
since 28th December 2024.
First order 20/12.
His appearance is regularized. Whether earlier his presence.
Your lordship, what had happened on 20th when the matter appeared, none appeared for the public prosecutor. So your
Is
lordship, the court
regularized
was pleased to appoint him.
to represent the estate in this case. Yes.
Please, your lordship,
Yes.
for the petition.
Short or long? What is this
matter,
matter?
my lord, very short matter. Petition, very short matter, my lord. Petitioner is the wife. Petitioner has been granted an interim maintenance of rupees 40,000.
Husband is not giving.
Husband is the income of the husband is 3,18,000 per month, and the maintenance has been given of rupees 40,000 per month.
Learned advocate for the petitioner.
One thing, child is suffering
Submits
from autism. A very
that despite
costly inadequate quantum
the
of
order of maintenance, husband is not.
But impugned order is passed by additional session judge. It is DV Act proceeding.
Not paying a single farthing to the petitioner towards the maintenance, despite the fact child is residing with her. The order, judgment and order the interim maintenance was granted in which proceeding?
In proceeding under the provisions of DV Act, my lord, by the learned magistrate. Thereafter, it was appealed before the additional sessions judge Barwipur. Additional sessions
Learned
judge,
magistrate, which magistrate?
judicial magistrate. But I'm showing, my lord.
Give me detail.
Judicial magistrate, first class, Barwipur, South 24 Parganas, my lord, page number 64.
First class, Baripur. First court.
No, my lord, only one judicial magistrate is there.
Where?
Only one judicial magistrate is there.
Baripur.
Barwipur.
Yes.
Page 64 and 65. Yeah.
ये लिख ले the monetary relief of rupees 15,000 was granted by judicial magistrate Barupur in criminal miss case number 60 of 2022 PR number 63 of 2022 on 7th September 2022 and whether this amount has been enhanced.
Well, it has not been enhanced, it has been kept same. But kindly
And
see
same was affirmed by which court?
by the additional sessions judge Barupur.
Additional Session Judge Baripur in criminal
appeal number 3 of 2022.
Appeal number 3 of 2022 on
my lord. On my lord, 27th June 2025.
27th June 2025. Prima facie sufficient material
But there is an affidavit of asset and liability which
is
shows that
available on record.
husband earns rupees 3,18,000.
Needs to be decided by hearing. Let the revision, let the instant revision be admitted for hearing. Petitioner is directed to serve notice to OP number 1, 2, 3 at their respective postal addresses and OP number 4 estate through the office of learned PP and file affidavit of service by the adjourned date. Let this matter appear in list on 19th September.
Well, I am praying for a short stay, my lord. Of the
stay of what?
Of the proceedings pending before the learned magistrate.
What proceeding is pending now?
Well, I meant the DV Act proceedings.
No, the order has already been passed.
No, that is my lord interim order.
Then why you want to want a stay of the proceeding?
But the stay of the proceedings pending before the learned magistrate. DV Act proceedings has been initiated. Interim order was passed. That was appealed in the sessions judge. Now my sessions judge affirmed the same.
Yes.
That's why I am praying for the stay of the proceedings before the learned magistrate. But final order.
You are husband.
But I am a wife.
Wife. So who filed application before the magistrate?
And the wife.
Wife.
My lord.
Then why you pray for a stay?
Well, let the revisional application be admitted.
Why you pray for a stay? Your petition. Proceedings should be proceed there, na?
Lord.
Yes.
Lord, intention to withdraw this item number 100.
You mention on mentioning slip, and that will appear under the heading of 2.
My lord,
my lord.
On the extremely unforeseen circumstances, I beseech you, my lord. Today my serial number is 30 and 32. It is a case of the widow. And only my humble prayer is let it get admitted, and for the expeditious disposal, let an opportunity be given to me to serve the copy. The charge sheet has already been filed.
Serve a copy to?
Serve copy to the opposite
What
party.
is your prayer?
For expeditious disposal.
For that service is not required.
My lord, only if this serial 30, 30 and 32.
It is better you place your matter on next day.
My lord says
no. By jumping,
at least 30, because she is a widow. At least 30, my lord, because she is a widow.
Passing any order by jumping the queue would not be
My lord,
good practice.
only 30 if it can be taken, because since 2020.
We'll take up on next date.
Kindly,
In your presence, now pass up.
Kindly fix it, my lord.
Because it will be in list, it will appear
under the heading fixed matter, that will.
Yes.